Ladies and gents, this is just to let you know that we are uploading files to the SATCOM website. It will be under a folder called PDFs. So it'll be in the PDF folder. Well, I'll rename it. Okay. We'll call it PDFs. And so it'll be a mixture. Let me get rid of Color Me Bad. I Adore Me More. I've listened to this song way too many times. And so we will skip to Nah Tyrese. I'm tired of listening to you. I put his new album on my computer, and you guys may or may not be able to hear the music because I'm in the car and I'm sitting here at the Wi-Fi hotspot uploading files, and it's a long trip. So let's see. It says it's queued 500 because you see it's a lot of files, people. So it only uploaded 65. Okay. The only problem is there is 5,000 files. So this is going to take a couple of sessions for me to get this up to you guys. I'll stay here the next hour uploading this, but the idea is we're going to put tons of documents up there for all of you to handle every situation: child support, mortgages, credit, everything. Okay, so let's just say that this is being done to help all of you. Now, there's a lot of people, we told everyone that we are going to be changing the price scale, okay, and we are, for SATCOMs, SAT packs, but that's not happening at the end of the month. We can't tell you when we're going to do it. We're just letting people know that it will happen because we're evaluating each of our SAT packs. And because of the way we're evaluating each of our SAT packs, and I didn't say evaluating, I said valuating. Because of the way we're evaluating each of the SAT packs, we will have no other choice. The cost will not be in proportion to the actual SAT pack value. It will be in proportion to the cost and fees that we have to incur in order to do this for you. Now, there are a couple of things that I want to show all of you, because while I am sitting up here waiting for all of this to take care of itself, and while we are sitting up here waiting for all of this to take care of itself, let's go ahead, because I got the air conditioning on because I'm told it's almost 100 degrees outside. And believe it or not, this very morning, on this very day, that's right, I said this very day, I had a jacket on because it was cold and I was freezing. Okay, and then I come here and it's 90 some degrees outside. That's one of the documents on child support, but I don't want any of these. We just downloaded Ninth Circuit document, and that's the document that I want. Oh, and let me show you guys what the Second Circuit. Let's talk about the Defrauded Homeowners of America. And I don't want you all to worry about this. We needed this to happen because without this happening, we couldn't make an issue of it. So the clerk of the court, see, mandate. You see that big, huge stamp? The clerk of the court, this is not from the court. Pay attention. See that right there? This is not from a judge. This is from the clerk of the court. They want us to pay. We're saying, no, we've already paid. We're not going to pay again because the Attorney General did not respond. We're making an issue of that. Haven't lost anything. But this is the clerk of the court who issued this. And you see a nice little seal they put on there? I'm not concerned about that. Oh, by the way, you see how she signed through the stamp? So please understand that that is a practice. Okay? So, but now you see this date right here, June 11, 2018? This is the date they claim this was going to be taken care of. But hold on, wait a minute. We got this last week, Friday. This came in on Friday, but the date on it says June 11th. Imagine that. And take a look, 7/13/2018. So they're just now letting us know. These are the games they are playing. Okay, so we will make sure that that's taken care of. Wanted to show you guys that right now so that you'll know that the matter isn't nowhere near but over. We are trying to handle stuff. Oh, by the way, you see all of this FOIA, POA, way to respond to commercial process, all of this stuff. Like I said, there are 76 items just on in this folder, and we're not even including all of those folders. So this is all of the information we're putting up there. Okay, so that's for y'all. Now, from my Microsoft Word, where you at, Word? Did I close my Word? I closed my Word. Oh no, my PDF Exchange. Okay, so let's see if I can pull up that Ninth Circuit document. Where you at, Ninth Circuit? Trustee, fiduciary duty of care, legal doctrine, no, not that one. You won't be under any kind of pressure. Not that notice of default. I believe this, nope, not that one either. I can't open any of those because those are not for you guys. There it is. Nope, this ain't it either. It's a new decision by the Ninth Circuit Court of Appeals. And so let me hold y'all for 1 second. Okay, ladies and gentlemen. I don't know why my Supremes were coming on so late. All right, this is the Ninth Circuit Court of Appeals case. I want you all to understand something about this case. This case is very important because you need to get this. Now it says for publication, but this is not the latest opinion. They reissued the opinion, and in other words, they amended their opinion for 2017. Okay, so this is the one before that, but this is where the information is important. This is where the Ninth Circuit Court lets you know what a debt collector is and what a debt collector isn't. All right, now what they're saying is that they're not swayed by the Second and Sixth and Fourth Circuit. See, disagreeing with the Fourth and Sixth Circuits and agreeing with the California Court of Appeals, and the panel held that a trustee was not a debt collector subject to damages. Ladies and gentlemen, they are lying. That is a lie. Let me show you why. Where's my dissenting opinion? Where you at, dissent? No, those are the facts. We don't want the facts. By the way, they'll always give you, pay attention, the courts on the appeals level will always give you facts. And where's the conclusion section? And they will give you conclusions because they have to give facts and conclusions of law. So that's why their orders will always include what they refer to as facts and then conclusions. I could just put conclusions. See, affirmed, vacated, remanded, and no costs. Why are they not charging the people? Anyway, pay attention. Since it was remanded, the plaintiff won, so she should get her fees back. Okay, definition of debt collector. I believe this is the dissent. Hold on. Or is this the Ninth Circuit telling you what the definition of a debt collector? And they give you the reasons why they disagree. Ladies and gentlemen, what you do with a case like this, you're not too much worried about what they're saying. Okay? Hold on. Let me make sure you understand why you're not. Because the judge who dissented, you got to give him some credit because he's not a fool. He's not stupid. He's not ignorant. He knows exactly what he was saying, and he used the law. Let's see. Give me 1 second, y'all. Like I said, I could have just put it in here, but I don't know the name of the dissenting judge. And guess what? It ain't here. It's all the way at the top. Oh, my God. So let me get rid of this thing and go all the way up here to the top. Because we started from the bottom, y'all. And now we're going to take it to the top. Okay. Give me 1 second. There he is, dissenting. All right. Judge Corman dissented in part and concurred in part. He wrote that the only reasonable reading of the Federal Fair Debt Collections Practices Act is that the trustee pursuing a non-judicial or judicial foreclosure proceeding is a debt collector because both proceedings are intended to obtain money by forcing the sale of the property being foreclosed upon. He also wrote that the FDCPA does not interfere with the California arrangement for conducting non-judicial foreclosures in a way that would justify nullifying the protections of the FDCPA that it provides, and the FDCPA preemption section provides ample room for the opinion of the California law. Judge Corman concurred with the remand to the district court for consideration of the Truth in Lending Act rescission cause of action. The lady said that she wanted to rescind her signature, and they were agreeing that she could. Okay, but this is what I want all of you to know. Okay, they explain what the steps of foreclosure are. The first step in the process, let's make this bigger. All right, the first step in the process by Recon Trust, a servicer, trustee, is to record the notice of default and mail it to the party. That's the California code. However, ladies and gentlemen, there's another step that they don't mention in here. Okay? Then there's another step that they don't mention. That's what I'm highlighting on. The steps they don't mention, because they want to focus on other things. I want to focus on several more things. And she brought the RISPA, Real Estate Settlement Procedures Act. RISPA. That's what RISPA stands for those of y'all who don't know. Hold on. We're going to overwrite. And we're going to, okay, we're going to always apply. Come on, always apply that action. There you go. Okay, right now we have uploaded over 283 items. This will be under the PDF section, and it will be the P.D.F.F.S folder where you will find all of these documents in. Okay, you're just going to have to go there. There are too many names. Eventually, we're going to rearrange that portion of our site. We will have to pay one of our members to take care of that. That will be taken care of. All right, hold on. We don't care about their discussion. We want them to tell us what a debt collector is, okay? And what a debt collector responsibilities are, okay? Because it says, in holding today, affirmed the leading case of Hoss versus Aquin Federal Bank, okay? What was decided in 2002, which held that foreclosing on a deed of trust is an entirely different path than collecting funds for a debtor, which is a lie. It is not an entirely different path. It is exactly for collecting of funds. Take a look at a notice of default and see, does it not highlight the funds being repaid? See, foreclosure is the payment of money. See, the ultimate purpose of foreclosure is the payment of money. The Sixth Circuit decided that because that's what the trustees' papers say. Okay? Said, following a trustee sale, the trustee collects the money from the home purchaser, not from the original borrower, because the money is collected from a trustee sale is not money owed to the consumer. It isn't debt as defined by the FDCPA. That's a lie. And that's where the dissenting judge comes in, because he lets you know that the FDCPA says that the funds can come from any party as long as it's going towards the payment of that debt. Then it's a debt collection activity. Okay, see, applies entirely to that regularly collects or attempts to collect directly or indirectly debts owed, due, or asserted to be owed or due to another. Entities that qualify as debt collectors under the general definition are debt collectors for the purposes of the entire statute. People, everyone, understand, directly or indirectly, as long as it's going towards paying down the debt, it is a debt collector. And that's what the dissenting judge said. The only problem is the young lady did not bring the arguments that the dissenting judge brought. So, ladies and gentlemen, what you do in your case is you bring the arguments the dissenting judge brought so that you can prove it is a debt collector. By the way, we had this attorney, this law firm, that was attempting to come at us as if they could collect the debt without validating the account. So let me show this to you right quick, y'all. Okay, we have to open up. Oh, this is the Ninth Circuit Court of Appeals. This is the final decision. in that case. See, if you see it says amended opinion, but you're going to see it's the same document. It says the same stuff. It's not going to change. Okay, but it says the panel held that even though the district court twice dismissed the plaintiff's Truth in Lending Act rescission claim, she did not repeal it in her third complaint. It was preserved for appeal because the district court instructed her that she would be required to allege the ability to repay the loan in order to state the rescission claim. The panel held blah blah under blah 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 blah. Okay, and decided after the district court dismissal that the mortgager needed not allege the ability to repay in order to state a rescission claim. Accordingly, the panel vacated the dismissal of the TILA, Truth in Lending Act claim, and remanded it for reconsideration in light of Marriott. The panel affirmed the dismissal of the other claims in a memorandum. Now, this is the dissenting judge talking about the FDCPA and how they are a debt collector. See, this is what the dissenting, Judge Corman, said. He wrote that the only reasonable reading of the FDCPA is that the trustee is pursuing non-judicial or judicial foreclosure, is a debt collector. Okay? It is to obtain money and forcing the seller of the property being foreclosed upon. So it is a debt collecting activity. Okay, now, it deals with all the counsel and where we just left off at. Now, let's get back because we got to make sure. Oh, y'all hear my girl in the background? She needs. Now, notice what says. Her appeal, she's arguing that Recon Trust is a debt collector because the notice of default and the notice to sell constitutes an attempt to collect the debt. Because both notices threaten foreclosure unless she brought her account current. Now, she should have stated that the calls to Recon Trust highlight the fact that they are attempting to collect the debt, and when she gave them the account number, they say they are attempting to collect the debt. They highlight they are attempting to collect a debt. That is the statement from their voicemail, that they are a debt collector. And you bring in the fact that they are registered with the state as a debt collector. Because they are registered as a state, as a debt collector, they are a debt collector. That's how you handle them, people. But nobody is doing this. This is how you prove they're a debt collector, is that they have to be registered with the state as a debt collector. Okay? The FDCPA imposing liability limits only on an entity attempting to collect the debt. For the purposes of the FDCPA, the word debt is synonymous with money. So, thus, Recon Trust would only be liable for attempting to collect money from Hope. That's the young lady's last name. And this, it did not do. Directly or otherwise, that is a lie. You see, when they sell the property, they are collecting money for the debt. Now, we want them to tell y'all what a debt collector is, the trustee is, because we need to know what a trustee is. So are you guys ready to find out what a trustee is? Hold on. You know what? I know what to do to get to that trustee part, because I'm not worried about these right here. Okay? I'm looking for it to describe what a trustee is. So let's go back to the original one, because like I said, it's the same thing, same information. Hold on. It's the exact same information. That's F, and let's see, FIRST. First, we need to go to first. Nope. Hold on one second. Nope, that ain't it either. Where's the first on this one? I don't see it. Hold on. That don't make no sense. I need first. I needed to say first. Okay, not that one. No. Oh, you know what? I didn't read this part before. Thus, in the first instance, the debtor agrees to allow the trustee to announce the foreclosure sale in the newspaper, as well as mail notices of default to various third parties, which is required under California law. Ladies and gentlemen, where does the debtor agree? Okay? Okay, you all need to pay attention. Okay, because in the two instances in which the California law allegedly conflicts with the FDCPA, the net effect is the borrower consents to permit the foreclosure to go forward in the manner prescribed by California law. The borrower permits the seller to go forward? Yes, because they don't respond. All right, now here's where it tells you who is party to the deed of trust. The loan was secured by a deed of trust. The deed of trust involves three parties. This is the case you use to explain the deed of trust involves three parties. Explaining California deeds of trust. This is the case. So, as a matter of fact, hold on, y'all. Hey, y'all know where I'm coming from? Well, apparently Anthony Hamilton knows where I'm coming from. Anthony, tell these people where we coming from. What I need is right here, y'all. I haven't looked up this case yet. And so I got to look up this case. So hold on while I woke up and I didn't make bail, y'all. Got time and a story to tell. It started when I was 9 years old. Woke up and daddy was gone. I started hustling and you couldn't tell me nothing. Fronting in the hood trying to be somebody. Sorry, I like this song. When I first heard it, me and this song, best friends. Because I tried to be good, y'all. Trying to keep from trouble. I don't like this. You see how this document is put together? I don't like it when they do it this way. I'm not used to reading it that way. So, uh-oh. Oh, yeah, it opens it up in my PDF exchange when I pull it up this way. So, no, I don't want to look at that document. I need to see. Let's do, yeah, we can do Justia. Okay, we're going to do this one. Okay, now I'm going to keep this up and then I'll transfer it to Windows. Oh, it has the PDF. Thank you. A university lifestyle looking kind of funky. All right, this is a Los Angeles County case. Now, the reason why this case is important is because this case explains what a deed of trust is. See, a loan, whether the borrower on a home loan secured by deed of trust may base an action on wrongful foreclosure and allegations purported assignment of the note or deed of trust to the foreclosing party barred defects rendering the assignment void. Okay, so definitely a case that I'm interested in, that I'm going to be going over. But hold on, we just pulled up that case because it mentioned it. We need y'all to pay attention. It said there are three parties to a deed of trust. One is the lender, who is the trust beneficiary. The second party is the borrower trustor or settlor or grantor, who it holds equitable title to the property. They not only hold equitable title, they hold another position to the property. They are the trustor of the agreement. They are the writer of the trust. They created the trust. The third party is the trustee, an agent for both the lender and the borrower, who is authorized to sell the property if the debtor defaults. What else is the trustee? Because this is the case which tells you the trustee only gets brought forth upon default. Before there's a default, there is no trustee. Pay attention. Before there is a default, there is no trustee. Okay, but what you want to really pay attention to is that the trustee is an agent for both the lender and the borrower. Well, how is he an agent? How is he a trustee for the borrower? What obligation does he owe the borrower? That's the point. And you want to hold on to that. He doesn't owe an obligation of foreclosing their house to the borrower. No, that's to the beneficiary. What obligation does he owe the borrower? That's your point. That's what you hold on to. All right. Ladies and gentlemen, this video was only give you guys a couple of updates and to give you some pointers on your lawsuits. I've given you information. You have to figure it out. Okay? I really have given you all the information on how to take care of your house and just showing you two cases. One, a case where the court amended its decision. Why? Because it knew it was stabbing itself in the neck. Okay. Hold on a minute. I don't know who that is coming on my radio like that. Okay. I don't know who that. No, we're going to do night shift before I take on off out of here. I don't know who no Hot Rock Candy or anything like that person was. I don't know who that was coming on my radio. I don't like playing songs I don't really know, especially when they sound like they ain't going to be a song like I really want to know. You know what I'm saying? All right, ladies and gentlemen, as the Commodores take us on out of here, Commodores, this is what Outliner Richie, and I thought this was a perfect song by them. And so, ever since this song came out, I have been a fan, and I will play it Oh, somebody called me while I was on this phone talking to y'all, and I didn't even see her number come in. So I'm going to have to call that young lady back because I called her earlier because we got to talk about this information right here, y'all. And so I'm going to have to get off of this, but I'm hoping that you get it. I'm hoping that the information proves beneficial to you. But again, as we told you, so that you see and you understand, we have so far put up 550, no, 570 documents. Okay, in just this short span, there is over 5,000 more documents to be uploaded. Okay, I will try to get those done by Sunday. But one thing you need to know, the information is being put up there for you all. Look, I have probably 60,000 PDFs on my computer. Okay, that's why my computer carries terabytes and not just gigabytes, because it's too much information. People are constantly sending me information. So I'm going to share the information that they freely share with me with you all. Okay? Now, when I say they share information, this is not their personal information. These are all files, and some of them are from seminars that other people have had and held, and the documents they included. So we're including that for you all. Okay? So as long as you found another home, there you go, on the night shift. Now, wait, one thing before I let you go, because you know this is what I do. Here's a little trivia for you. You guys know where the term night shift comes from? Like he works on a night shift? Well, this song is talking about the actual real night shift. See, it's talking about those people who have passed away. Okay, we got Jackie, and then we got Marvin. Two people that they're highlighting in the song. Jackie, Jackie, oh. Okay, anyway, ladies and gentlemen, the night shift came from, there was a period in time in American history, English history, where individuals would drink from cups that were made out of lead. They were making cups out of lead. It was a cheap source and it was easy to manipulate, and so they made dishes out of lead. Well, however, lead and alcohol has a unique chemical reaction, and because lead has a chemical reaction, it would cause people to be comatose. That was one of the side effects. It put you to sleep. But it put you to sleep so well that you appear to be dead. And so it was thought that these people had died. And so when these people would be there, no pulse, and dead, they would bury them. And these people would end up being buried alive. Now, remember, they were buried 6 feet underground, so how did they know they were being buried alive? Well, when they would have these big, huge floods and these big, huge storms, the coffins would come above ground. And they would notice that the inside of the coffins had scratch marks, which indicated that they were burying these people alive. So they came up with a plan. They tied a string to the toe of the person who was being buried. And that string led all the way over to the agent who was sitting at the graveyard. That's why it's called the graveyard shift. Night shift, graveyard shift. Okay, he's working graveyard. That's where the term comes from. And there would be a bell tied at the end of the string at the graveyard where the individual would be watching to listen for the bell to ring. You heard the phrase, for whom the bell tolls? That's where that comes from. So you can learn a lot from a dummy. And so if a person was buried and they were still alive, then the bell would ring, the person would go and dig them up, and there you go, a life saved. So that's where you get night shift and graveyard shift, is because the individual who was working the graveyard would be there taking a shift, taking a turn. So graveyard shift, night shift. There you go. See, you learned something. Have a good day, everyone. I'm not just all ears. Goodbye.